Hi, I'm attorney John King with Cannon Associates. In today's video, I'm going to be answering some of the most common questions we have about drug charges. One of the most common questions we get from potential clients or the family of potential clients is, what's the difference between drug trafficking and aggravated drug trafficking? What's the difference between drug trafficking and possession with intent to distribute drugs? The difference between drug trafficking and possession with intent to distribute is really what the definition or requirements are of those separate offenses. And the difference between drug trafficking and aggravated trafficking is solely based on the amount of drugs. What do I mean by that? Possession with intent to distribute in Oklahoma requires the government or the prosecutor to prove that you possess drugs either constructively, like you had dominion and control over drugs in a different location, or you physically possess the drugs, like they're in your immediate grab area or within a location that you obviously are in control of those objects. In addition to the possession, the government must show that you had an intention or a plan or a design to distribute, sell, share, or potentially even give away those drugs. So yes, possession with intent to distribute does capture the typical individual or the prototype that you'd expect, someone that is selling drugs on the street, a drug dealer per se. But it also can include someone that just has an amount of drugs that it looks like there's indicators that they are sharing those with others. Some of the factors the government looks for in trying to prove an allegation of possession with intent to distribute drugs is scales, or individually wrapped amounts of drugs, or large amounts of cash, or a drug ledger, like a notebook that has different transactions on it, like a different type of business may keep. Information or things that show that an individual is going to sell or distribute or share the drugs, these are the types of pieces of evidence that may lead the prosecution to file possession with intent to distribute drugs as opposed to simple possession of drugs. One of the big problems with that distinction is that now in Oklahoma, the legislature, in a moment of wisdom, decided to make possession of drugs a misdemeanor offense. So no longer are people facing the fear and concerns of a felony offense for simply possessing personal use of drugs, even illegal drugs. Possession with intent to distribute is still a felony in Oklahoma, and a serious felony that can carry prison time. Now turn to the issue of drug trafficking. Yes, drug trafficking can encapsulate instances like you see in TV or movies of hundreds and thousands of pounds of drugs, like the cartel or other people that are moving serious amounts or serious weights of drugs. But it also can include, or our legislature has determined, it can capture people with much, much smaller amounts of drugs. Drug trafficking is solely based on the weight of the specific drug in question. So the amount of drugs necessary to be drug trafficking for marijuana differs from the amount of drugs necessary to be charged with drug trafficking for cocaine or heroin or fentanyl or ecstasy or any other type of illegal drug or a controlled dangerous substance as they're defined in our statutes and federal statutes. The difference between drug trafficking and possession with intent is that there's no intentionality or motive required. For drug trafficking, all the government has to show is that you actually or constructively possessed an amount of drugs above the weight requirement to meet trafficking in the state of Oklahoma. Therefore, it's very important that you and your defense attorney look at those weights and what the government can actually prove. If the amount of drugs found is very close to the cutoff for drug trafficking in your specific offense, it's important to make sure the government tests those drugs, that they're weighed by the Oklahoma State Bureau of Investigation's OSBI, an actual drug lab, as opposed to at the police station. Because if the government has less drugs or a smaller weight of an identifiable trace amount of that drug in a substance that's found, then the government can't prove drug trafficking, and it must be a less serious offense. Now turning to the most serious type of crime that we have related to drugs in the state of Oklahoma, and that's called aggravated trafficking. And it's basically as simple as the terms sound. The trafficking is aggravated, or it's trafficking times 2. Aggravated trafficking is just dependent on the weight or the amount of drugs that are found with that individual or found in the case at bar. Aggravated drug trafficking means that you have possessed or allegedly possessed, or a group of people have allegedly possessed, an amount of drugs above the statutory threshold, not only for trafficking, but the weight for aggravated trafficking in the state of Oklahoma. So if someone is charged with trafficking in marijuana and they have X number of pounds of marijuana, If that number of pounds is above the requirement for aggravated trafficking, then you would be charged with that offense as opposed to simple trafficking. Again, there are multiple things that you and your defense attorney can do to try and defend your case, both mitigating, extenuating, but also fighting legal issues, search and seizure issues, documenting what the police did or didn't do, whether they followed the rules or not, whether the stop that took place in your case or the search that took place in your case was legal, whether your rights were violated or not. We represent tons of clients facing these types of issues, walk them through this circumstance, and do everything in our power to make sure that the government has met its burden and followed the rules as they've interacted with our clients. One last point on aggravated trafficking is it is unfortunately a crime identified as an 85% crime in Oklahoma, meaning under a statute that defines specific very aggravated offenses according to our legislature, Title 21, Section 13.1, if you're charged and convicted of the crime of aggravated trafficking and sent to prison, you would be required to serve 85% of your sentence before being considered or eligible for good credits to move you towards parole or release from that prison sentence. Which means that if you were to receive 10 years in prison, you would have to serve 8.5 years of that sentence before you could be considered for parole or early release. I hope this video has answered some of the most common questions you have, as we found it answers some of the most common questions we receive from our clients concerning aggravated trafficking, drug trafficking, possession with intent, and some of the issues that go into those types of cases. If you have other questions about this or just curious about these laws, we welcome you to reach out to Cannon & Associates, your fierce advocates, and we'd be happy to answer your questions. And if you or your family are facing something like this, we'd be happy to speak to you about what it would take for us to help you in your specific case.